The Attorney General for Kentucky, Mr. Daniel Cameron, is on the phone with us this morning. Good morning, Mr. AG.
Good morning, Randy. How are you?
Hey, I'm doing great. I noticed you had a press conference about the topic that we're going to discuss this morning yesterday on the steps of the Capitol. And I know just enough about this, Daniel, to be dangerous. But from what I understand is that in 2018, the General Assembly passed House Bill 454. It's the Human Rights of Unborn Children Act. And since then, it's been in court.
That's right.
And former Attorney General Andy Beshear, I guess, decided not to defend. And then when he got in the governor's office, obviously he's not done so, even though Matt Bevin did pick it up back when. But since then, they sort of dropped the ball. And you've been fighting just to get to defend the law. Am I right?
That's exactly right. I tell people that, as you noted, this law was passed in 2018. And really what it does, it's a ban on live dismemberment abortions, which says that we don't want the procedure to occur, but if it does, and again, we don't want it to, we don't want children to feel pain in the womb when that procedure happens. And so it was immediately challenged in 2018. By the time it got to the Sixth Circuit Court of Appeals, there had been a switch, musical chairs, if you will, in state government. And so I came into the AG's office, and my predecessor moved it to the governor's office. Interestingly, we actually had a joint agreement to defend this law at the Sixth Circuit Court of Appeals. So the governor's office, Governor Beshear, had actually hired us to defend the law. You get two bites of the apple at the Sixth Circuit Court of Appeals. We lost on that first bite. At that point, the governor said, you know what, I'm washing my hands of House Bill 454, which we thought was unfortunate. But we said, you know what, the AG is tasked with the responsibility of defending the law. So regardless of what the governor's office does, we should continue. We've been empowered to do so by the General Assembly, so we should continue to defend this pro-life measure. Sixth Circuit said, no, it's too late. We refused to take no for an answer, frankly, and said that on an issue of this importance, we'll take the matter of whether we can represent Kentucky in it all the way to the United States Supreme Court. So that is what was before the Supreme Court on October 12th. We'll have a hearing. My Deputy Solicitor General, Matt Kuhn, is well knowledgeable on and learned on this issue, is going to be arguing in front of the Supreme Court. I'll be up there rooting him on. And I'm hopeful that if we prevail, we can go back to the Sixth Circuit Court of Appeals, knock on the door and say, finally, let us in. Defend this law, and we'll continue to defend this pro-life measure.
What I can understand about this, Daniel, this pretty much can be a landmark case about every state's ability to rather defend its laws in federal court.
That's exactly right. That this is a case at its base about the sovereignty of a state to be able to determine who gets to decide, who gets to represent that state on legal matters.
I mean, that's why you were elected as Attorney General to defend our laws.
That's exactly right, Randy. And so the General Assembly has said repeatedly in statute that the AG's office works as a fail-safe, meaning that if, regardless of what any other agency or what the governor's office decides to do, that in terms of defending the laws of the Commonwealth, that responsibility, again, as a fail-safe, resides in the AG's office. So we are taking that responsibility seriously, and that's why this case is so important to Kentucky and really all of our states.
And really, if you happen to win your argument before the Supreme Court, your work really just starts, right?
It's just beginning, my friend. It's just beginning. Yes, we will be right back in the Sixth Circuit Court of Appeals asking, again, for that second bite at the apple, if you will, to continue defending House Bill 454. Why it's so important that we get that second bite is because in the intervening period, meaning after they ruled against us the first time, the Supreme Court decided what's called June Medical. This is getting a little bit technical, but June Medical was a case that was a pro-life case. And basically what the court said is that this balancing test that had been used previously to look at pro-life issues or pro-life laws that are passed in the states the court basically got rid of that balancing test and is now encouraging the federal courts to look at a more fact-specific analysis or undertake a more fact-specific analysis of pro-life cases. So we think that will help in changing the mind of the Sixth Circuit as it relates to House Bill 454. That's why it's so important that we get back in that court and argue the merits, the substance of House Bill 454.
You answered my question before I ever asked it, because that was going to be what makes you think the second time to these same guys?
Yeah.
So things have changed. So I like your odds.
Yes, I like our odds too. And again, like I've told folks, we don't want to put the cart before the horse.
Right.
We got to make sure that we're victorious in the Supreme Court. I think we've got good law on our side. And again, I think at base, the idea that a state decides who gets to represent it rather than a federal court, I think it's a pretty big deal. And I'm hopeful that the Supreme Court will say, you're right. The Sixth Circuit shouldn't have told you couldn't jump in. You need to be able to jump in and defend the law as the representative of your state. So I'm hopeful that's what happens.
I don't know about you, but I'm seeing this more and more in numerous things where the federal government is really overreaching into the sovereignties of states.
Well, you're right about that. We had a case, you might recall, that we won actually a few weeks ago when this most recent round of COVID money went into the states, and you can certainly argue about whether we needed that most recent tranche of money to come to the states.
Right.
But there was a condition put on it by the Treasury Department. Secretary Yellen, the treasurer, said, if you take this money, you cannot change your state tax policy, meaning in Kentucky and other conservative states, if you cut taxes, we might take your COVID money away from you. Well, that is, again, an intrusion into state matters,
right.
A state sovereignty, a state's decision as to what they want to do with their tax policy. So we actually went into federal court to argue, Randy, just what you said, that a federal government shouldn't be able to tell a state what to do with its tax policy. We won that case at the first rung at the federal courts, at the district court level. We got an injunction. We stopped what the Treasury Secretary was trying to tell Kentucky, so we can continue here to do what we want with our tax policy, because, again, that is a function of a state and a function of our legislature rather than the federal government.
And I know I got to let you go. I could talk to you all day, but and I talk about this all the time, is that I think the General Assembly got it right in this last session where they returned the mask mandate decision to local communities and school boards.
That's exactly right. What the legislature said is that we want our specific counties, our local officials, our citizens in our respective counties to be able to make decisions about what's most important as it relates to, kids at school, or how we operate in terms of mask mandates, if you will, and how we respond to this pandemic. I think it was an appropriate decision made by the General Assembly. And moreover, that decision and the power to change the emergency powers and the emergency statutes was affirmed by the state Supreme Court. The state Supreme Court in the case Cameron versus Bashir, when the governor sued because the legislature had made those changes, said, no, Governor, the legislature has the power to make those changes, and you need to respect that.
And I think he's overreached some too, but that's another topic. Daniel, thank you so much. I think you're doing a great job as AG. We appreciate you checking in with us. I'm going to give you one more tough question before I let you go. I know you're really busy. Kentucky, LSU, who you picking?
Oh, Kentucky all the way.
Did you watch the Florida game?
I absolutely did. My father-in-law was at that game, and so he was sending us live shots and videos of those last few minutes. It was wild, and I'm a fan of the Commonwealth, and was glad to see the Cats when they are on a roll.
Well, they are, and I hope they continue this Saturday night. Hey, thank you, my friend, and you're always welcome to check in with us here in East Kentucky.
Well, I enjoyed, my friend. Talk to you soon, Randy.
All right. Attorney General Daniel Cameron, and we appreciate him joining us this morning. So.